Good day, ladies and gentlemen. My name is Carla and I'm a Labour Legal Advisor at SEESA Cape Town.
Good day, ladies and gentlemen. My name is Stefan Tickner. I'm also a Labour Legal Advisor in Cape Town. We often get questions from our clients on how to terminate the services of an employee immediately. Now, this is not a simple question. We have the Labour Relations Act primarily that guides us on the requirements and the procedures to be followed for a fair dismissal. This is the topic we're going to be discussing today.
Yes, that's correct. So the Code of Good Practice on Dismissal determines that there are only 3 grounds on which one can justifiably terminate an employee's employment. That's based on the employee's conduct, based on the employee's capacity, and based on the employer's operational requirements. If a dismissal is not based on one of these 3 grounds, it will be unfair, irrespective of the procedure followed, irrespective of the notice period given. Stefan, will you start us off by explaining to us how one can legally dismiss an employee based on their conduct?
Absolutely. So when we look at misconduct, we look at procedural fairness and we look at substantive fairness. That means we must have fair reasons and we must follow the right procedure in order to terminate fairly. So an employer must always ensure that there is a disciplinary code implemented in the workplace and that staff members are made aware of this code. The employer will use this code to determine the appropriate measures to be used when disciplinary misconduct is committed, and employees will then know what will happen if they commit a specific misconduct. It's extremely important for an employer to be able to show that there is a rule in the workplace and that that rule has been broken before misconduct can be prosecuted, so to speak. Now, the employer will use a progressive discipline as endorsed by the Code of Good Practice in the Labour Relations and our courts to address most disciplinary misconduct. And this entails the issuing of warnings depending on the seriousness of the event before the employer commits to dismissing an employee for misconduct. Summary dismissal for a first offence is really only reserved for extreme or severe forms of disciplinary misconduct.
Absolutely, and as Stefan mentioned, for dismissal to be fair, it must be procedurally fair as well. The Code of Good Practice dictates that an inquiry has to be held before an employee is legally dismissed. Now, this starts off by the employer properly investigating the alleged misconduct and determining whether or not the misconduct actually does justify dismissal. Now, once it has been determined by the employer that it could potentially justify dismissal, the employee must be made aware of the misconduct he or she is being charged with. This must be done in a language which the employee can easily understand. Now, the employee must also be given a fair opportunity to make representations as to the charges levied against him or her, and must be made aware of their right to representation during the inquiry. Now, at the conclusion of the inquiry, if the employer is still of the opinion that dismissal is justified, the employee must be made aware of the dismissal, must be made aware of the reasons for the dismissal, and must be made aware of his or her right to either appeal or refer the matter to the CCMA or relevant bargaining council. Now, what's very important from a procedural perspective is that an employer must institute disciplinary proceedings consistently. You can't dismiss an employee for the same misconduct for which you gave a previous employee a final written warning. Now, let's move on to the second justifiable reason to terminate an employee's employment, which is the capacity of the employee. This can be divided into 3 categories, which is firstly the employee's poor work performance, secondly the employee's ill health, and thirdly general incapacity. Stefan, will you start us off by explaining the poor work performance procedure, please?
Yes, absolutely. So poor work performance entails an investigation into the employee's ability or capacity to perform the work he's been employed to do to the standard expected from his employer. So the employer must make the standard known at the onset of employment, and if the employee does not meet the standard, it is extremely important for the employer, even during the probationary period, to inform the employee that he is not meeting the standards required of him. The employer must give the opportunity for the employee to improve, but also to make representations to the employer regarding his alleged poor work performance. And he must be given the opportunity to improve his poor work performance over an agreed period of time. The employer, after the expiry of this agreed period of time, will then reassess the employee's performance. and make a determination if the performance has improved or not. If the improvements are not there, the employer then resorts to an inquiry process where an objective chairperson then determines whether the employee is still fit to further attempt improvement or whether dismissal is appropriate. And this entails one of two things. So in the first instance, either the extension of a probation to try and further improve, or a termination on poor work performance incapacity, which, remember, always entails notice periods. We also have the second form of incapacity, which is ill health. Again, this is regulated by the Code of Good Practice, Schedule 8 of the Labour Relations Act. Carla, would you discuss ill health for us?
All right, so ill health obviously caters for a situation where an employee becomes incapacitated as a result of an illness or a disability. Now, one cannot simply dismiss an employee on the basis that they are unfit as a result of an illness or a disability. As with everything else in labour law, and a procedure has to be followed. Now, this starts by the employer actually investigating the illness, or the nature rather, of the illness or the disability, and determining to what extent it will actually impact the employee's performance of his or her duties and responsibilities. If it becomes apparent that, well, it will have quite a severe impact on the employee's employment, the employer must first try and find an alternative position in the company for the employee, or amend the employee's responsibilities and duties as to accommodate the illness or the disability. Only at an inquiry after it's been established that there is no alternative position, the position that the employee is currently in cannot be changed to accommodate the disability or the illness, may a dismissal in fact be effective. Now, the third form of incapacity, which is known as general incapacity, is not regulated by law. This caters for a situation where an employee, as a result of an external factor, is incapable of executing his and her duties and responsibilities. This would be where an employee has a criminal record, perhaps in an industry where you're not allowed to work if you have a criminal record, or where an employee doesn't have the necessary work permit or the necessary licensing. Now, it's very important to note that the onus is on the employer to establish at the commencement of the employment relationship whether this employee actually has the capacity to execute their duties. In other words, the employer has to establish whether or not there is a criminal record. The employer has to establish whether or not you have a permit or the necessary licensing. If during the course of my employment I become incapacitated as a result of any of the aforementioned, there's again a procedure to be followed. The employee must be made aware of the fact that they've been incapacitated. They must be given a reasonable opportunity to make representations as to why and perhaps offer solutions. And in certain circumstances, they will also have to be given a reasonable opportunity to obtain the necessary documentation to actually enable them to continue executing their duties and responsibilities. Only if at an inquiry it has been made very clear that the employee will be incapacitated on a permanent basis may one actually resort to dismissal.
Yes, and that brings us to our last form of dismissal, and that is a dismissal or termination for operational requirements, or generally referred to as a retrenchment. Now, ladies and gentlemen, there's been previous recordings on this topic, and we urge you to go and listen to those. I think what we've established primarily today is that the requirements and the procedures to be followed when terminating service is vitally important. We urge employers to contact with SEESA to discuss the matter on a case-to-case basis and ensure that the right reasons are there and that the right procedure is followed. A dismissal or an unfair dismissal at the CCMA could have severe consequences in the form of compensation and awards. Ladies and gentlemen, it seems that that is all that we have time for today. Thank you so much for listening to us.
Thank you very much.